Other lawyers and even members of the HRTs themselves regard Canada's human rights tribunals with head-shaking disbelief. A gong show, one lawyer called them. A crapshoot, said another. Now I'm going to meet one myself. That's my subject on today's Fiamengo File. I'm Janice Fiamengo of the University of Ottawa. In this video, I'm not going to speak about the human rights violation charge against me, though I will do so in time. Instead, I'm going to speak in general about Canada's human rights tribunals and what they mean for freedom and justice in this country and across the West. And to all those who donated to my legal defense, I am more grateful than I can say. I've always had a horrified fascination with our tribunal system, which proposes to eliminate what it calls hate or discriminatory attitudes by fining people and shaming them publicly. The tribunals work on the principle that you can actually force people to respect others by punishing them over even trivial misunderstandings or honest expressions of opinion. They elevate certain individuals and groups into protected classes of people who know they can get money out of others by claiming to feel hurt or threatened by something that was said or done. The whole system makes people afraid to say what they really think. It creates a climate of suspicion and opportunism, of revenge and resentment. In two infamous cases, Ezra Levant was prosecuted for publishing the Danish cartoons of Muhammad, and Maclean's magazine had to defend itself for publishing Mark Steyn on the potential consequences of large-scale Muslim immigration to Canada. Both of these respondents eventually won their cases, but at enormous cost in time and money. And this is how the tribunals work. Even when the respondent is not found guilty, they've still been punished. And other magazines and individuals will think twice about publishing anything that might be deemed hateful. Ezra Levant and Mark Steyn are, of course, media personalities with large followings and powerful resources. But we don't hear about all the other cases involving ordinary people, people who lack the money and or the public profile necessary to defend themselves and who have been quietly having their lives turned upside down by our human rights watchdogs, who are certain that they know how to create a social utopia. So as I sat in the lobby of the building where the mediation session was going to take place for my case, a session that failed, I felt as if much of my adult life had been leading to the moment in which I would stand before the Ontario Human Rights Tribunal. I've been a thought criminal for a long time. According to its cheerful website, the Human Rights Tribunal of Ontario, which is one of 7 tribunals that fall under the Social Justice Tribunals Ontario, states that it, quote, resolves claims of discrimination and harassment brought under the Human Rights Code in a fair, just, and timely way, end quote. What that means is that if you're a small business owner or a manager in an office or school or the president of a condo board, etc., a disgruntled employee or client can bring a complaint against you and your small business, alleging that you discriminated on the basis of race, sex, disability, religion, or what have you. There's a substantial list of the prohibited grounds of discrimination on the Ontario HRT website. And for that, you can spend at least a year, in many cases much longer, defending yourself before a quasi-legal tribunal. If found guilty, you can be required to undergo re-education training, pay thousands of dollars in compensation to the complainant, or spend tens of thousands of dollars to change your business to bring it into compliance with the code. In most cases, the rulings are final and cannot be appealed. Human rights tribunals use legal-sounding terms like complainant and respondent and have legal power to compel compliance, including compliance to pay the fines they levy. But they do not operate according to traditional legal principles. Unlike in regular courts of law, they do not begin with the presumption of innocence, and the complainant need not prove discrimination beyond a reasonable doubt. Instead, tribunals use the balance of probabilities model, which means discrimination merely has to be shown to have been more likely than not. In other words, 50% plus 1. As the Human Rights Legal Support Center explains to prospective complainants, it can be hard to prove discrimination absolutely, but that doesn't mean you shouldn't try. The website counsels as follows, quote, "Discrimination may be hidden or subtle and can be the product of unspoken beliefs, biases, and prejudices. This means that in many cases, discrimination can only be proved by drawing inferences and conclusions from the circumstances surrounding an instance of negative or unfair treatment. To prove discrimination, you must be able to show at your hearing that it is more likely than not that in all of the circumstances, discrimination was a factor in the events or actions." End quote. Note the waffly language. Discrimination is not always overt, i.e., the person accused doesn't have to actually state their supposed bigotry overtly. Often the discrimination can only be, quote, proved by, quote, drawing inferences from the circumstances, end quote. In other words, it doesn't have to be proved at all. It is inferred. If I infer something, I'm presuming it. I'm speculating. I'm even guessing. I'm not drawing a strictly logical, evidence-based conclusion. And given that Canadian society is supposedly permeated by racist and sexist and other forms of discriminatory hatred, it is all too likely that in the SJW mind, any instance of negative treatment can be inferred to spring at least partly from discriminatory beliefs or prejudices. This is a recipe for finding human rights abuses everywhere. Unlike regular courts of law, tribunals don't provide legal counsel to the accused. In most cases, a respondent, someone accused, simply has to go in there and take his chances with accusations of racism or sexism or any other kind of horrible bigotry, with all the attendant shame, discomfort, and uncertainty. The respondent spends months waiting, wondering, questioning himself, answering others' questions. He'll have to try to prove that in his heart, he doesn't harbor hatred against Croatians or the disabled or cross-dressers or whatever, even while dealing with an adjudicator who suspects he likely does, because we know what a problem bigotry is in our society. The vast majority of adjudicators are not judges, but are rather social justice advocates who studied law less because of a passion for law itself than because of their desire to change the world, to make it better for victims. Take a look yourself at the list of social justice tribunal members to get a sense of who decides the cases. The vast majority of them are involved with one or more of feminist, environmentalist, anti-racist, anti-poverty, or disability rights activism, and so on. They're hardly impartial. The Human Rights Tribunal is a place where self-proclaimed victims, without having to prove beyond a reasonable doubt that a law was broken, can get compensation for their claimed grievances, and where social justice advocates peer into the tainted souls of the accused to consider whether it is more likely than not that prejudice may have played some role in their actions. Proof that the entire tribunal system is slanted toward the complainant's rights rather than those of the accused is found on the website, which is almost entirely focused on complainant issues, such as how to file a complaint or how to calculate the interest on any money awarded, and so on. Yeah, that's right. The defendant may have to pay interest on any money he or she is forced to pay to the complainant based on the time that has elapsed between the date of the alleged discriminatory incident and the date years later when the Human Rights Tribunal finally makes its ruling. It's a system that invites people with complaints to come forward and try their luck, because they very well might profit from the experience or at least work out their spleen at no cost to themselves except their time. A complainant can pull out of the process without penalty at any time if it looks as if the case isn't going their way. They can simply abandon the whole thing. And no compensation for the time and money lost or the personal stress involved is ever offered to the respondent. And if you're the respondent, you aren't allowed to sue the complainant for whatever terrible, untrue things they alleged about you due to the tribunal's non-retaliation rules. So what do you think? Is this a system that is likely to produce peace and harmony in society? Or is it likely to produce fear and resentment, opportunism, and false claims of discrimination? You already know what I think. So am I exaggerating? Am I misrepresenting the kinds of cases the tribunals deal with and the kinds of judgments they render? In my next video, I'm going to tell you about 2 typical cases that came before the Ontario Human Rights Tribunal in the past decade to give you a flavor of the tribunal's vision of justice. What I found confirms the satirical witticism that SJWs are people who read Orwell's 1984, not as a warning, but as a manual. Please stay tuned.